Article 301. The right to receive support cannot be renounced, nor can it be transmitted to a third person. Neither can it be compensated with what the recipient owes the obliger. However, support in arrears may be compensated and renounced, and the right to demand the same may be transmitted by onerous or gratuitous title. 151. Article 302. Neither the right to receive legal support nor any money or property obtained as such support, or any pension or gratuity from the government is subject to attachment or execution. N. Article 303. The obligation to give support shall also cease: 1. Upon the death of the recipient. 2. When the resources of the obliger have been reduced to the point where he cannot give the support without neglecting his own needs and those of his family. 3. When the recipient may engage in a trade, profession, or industry, or has obtained work, or has improved his fortune in such a way that he no longer needs the allowance for his subsistence. 4. When the recipient, be he a forced heir or not, has committed some act which gives rise to disinheritance. 5. When the recipient is a descendant, brother or sister of the obliger, and the need for support is caused by his or her bad conduct or by the lack of application to work, so long as this cause subsists. 152a. Article 304. The foregoing provisions shall be applicable to other cases where, in virtue of this code or of any other law, by will, or by stipulation, there is a right to receive support, save what is stipulated, ordered by the testator, or provided by law for the special case. 153a. Title X. Funerals. N. Article 305. The duty and the right to make arrangements for the funeral of a relative shall be in accordance with the order established for support, under Article 294. In case of descendants of the same degree, or of brothers and sisters, the oldest shall be preferred. In case of ascendants, the paternal shall have a better right. Article 306. Every funeral shall be in keeping with the social position of the deceased. Article 307. The funeral shall be in accordance with the expressed wishes of the deceased. In the absence of such expression, his religious beliefs or affiliation shall determine the funeral rites. In case of doubt, the form of the funeral shall be decided upon by the person obliged to make arrangements for the same, after consulting the other members of the family. Article 308. No human remains shall be retained, interred, disposed of, or exhumed without the consent of the persons mentioned in Articles 294 and 305. Article 309. Any person who shows disrespect to the dead, or wrongfully interferes with the funeral, shall be liable to the family of the deceased for damages, material and moral. Article 310. The construction of a tombstone or mausoleum shall be deemed a part of the funeral expenses, and shall be chargeable to the conjugal partnership property, if the deceased is one of the spouses. Title She. Parental Authority. Chapter 1. General Provisions. Article 311. The father and mother jointly exercise parental authority over their legitimate children who are not emancipated. In case of disagreement, the father's decision shall prevail, unless there is a judicial order to the contrary. Children are obliged to obey their parents so long as they are under parental power, and to observe respect and reverence toward them always. Recognized natural and adopted children who are under the age of majority are under the parental authority of the father or mother, recognizing or adopting them, and are under the same obligation stated in the preceding paragraph. Natural children by legal fiction are under the joint authority of the father and mother, as provided in the first paragraph of this article. 154a. Article 312. Grandparents shall be consulted by all members of the family on all important family questions. N. Article 313. Parental authority cannot be renounced or transferred, except in cases of guardianship or adoption approved by the courts, or emancipation by concession. The courts may, in cases specified by law, deprive parents of their authority. N. Article 314. A foundling shall be under the parental authority of the person or institution that has reared the same. N. Article 315. No descendant can be compelled, in a criminal case, to testify against his parents and descendants. N. Chapter 2. Effect of parental authority upon the persons of the children. Article 316. The father and the mother have, with respect to their unemancipated children, 1. The duty to support them, to have them in their company, educate and instruct them in keeping with their means, and to represent them in all actions which may redound to their benefit. 2. The power to correct them and to punish them moderately. 155. Article 317. The courts may appoint a guardian of the child's property, or a guardian ad litem when the best interest of the child so requires. N. Article 318. Upon cause being shown by the parents, the local mayor may aid them in the exercise of their authority over the child, if the child is to be kept in a children's home or similar institution for not more than 1 month. An order of the justice of the peace or municipal judge shall be necessary, after due hearing, where the child shall be heard. For his purpose, the court may appoint a guardian ad litem. 156a. Article 319. The father and the mother shall satisfy the support for the detained child, but they shall not have any intervention in the regime of the institution where the child is detained. They may lift the detention when they deem it opportune, with the approval of the court. 158a. Chapter 3. Effect of parental authority on the property of the children. Article 320. The father, or in his absence the mother, is the legal administrator of the property pertaining to the child under parental authority. If the property is worth more than 2,000 pesos, the father or mother shall give a bond subject to the approval of the court of first instance. 159a. Article 321. The property which the unemancipated child has acquired or may acquire with his work or industry, or by any lucrative title, belongs to the child in ownership and in usufruct to the father or mother under whom he is under parental authority and in whose company he lives. But if the child, with the parents' consent, should live independently from them, he shall be considered as emancipated for all purposes relative to said property, and he shall have over it dominion, usufruct and administration. 160. Article 322. A child who earns money or acquires property with his own work or industry shall be entitled to a reasonable allowance from the earnings, in addition to the expenses made by the parents for his support and education. N. Article 323. The fruits and interest of the child's property referred to in Article 321 shall be applied first to the expenses for the support and education of the child. After they have been fully met, the debts of the conjugal partnership which have redounded to the benefit of the family may be paid from said fruits and interest. N. Article 324. Whatever the child may acquire with the capital or property of the parents belongs to the latter in ownership and in usufruct. But if the parents should expressly grant him all or part of the profits that he may obtain, such profits shall not be charged against his legitimacy. 161. Article 325. The property or income donated bequeathed her device to the unemancipated child for the expenses of his education and instruction shall pertain to him in ownership and usufruct. But the father or mother shall administer the same, if in the donation or testamentary provision the contrary has not been stated. 162. Article 326. When the property of the child is worth more than 2,000 pesos, the father or mother shall be considered a guardian of the child's property, subject to the duties and obligations of guardians under the rules of court. N. Chapter 4. Extinguishment of parental authority. Article 327. Parental authority terminates 1. Upon the death of the parents or of the child. 2. Upon emancipation. 3. Upon adoption of the child. 4. Upon the appointment of a general guardian. 167a. Article 328. The mother who contracts a subsequent marriage loses the parental authority over her children, unless the deceased husband, father of the latter, has expressly provided in his will that his widow might marry again, and has ordered that in such case she should keep and exercise parental authority over their children. The court may also appoint a guardian of the child's property in case the father should contract a subsequent marriage. 168a. Article 329. When the mother of an illegitimate child marries a man other than its father, the court may appoint a guardian for the child. N. Article 330. The father and in a proper case the mother shall lose authority over their children. 1. When by final judgment in a criminal case the penalty of deprivation of said authority is imposed upon him or her. 2. When by a final judgment in legal separation proceedings such loss of authority is declared. 169a. Article 331. Parental authority is suspended by the incapacity or absence of the father, or in a proper case of the mother, judicially declared, and also by civil interdiction. 170. Article 332. The courts may deprive the parents of their authority or suspend the exercise of the same if they should treat their children with excessive harshness or should give them corrupting orders, counsels, or examples, or should make them beg or abandon them. In these cases, the courts may also deprive the parents in whole or in part of the usufruct over the child's property, or adopt such measures as they may deem advisable in the interest of the child. 171a. Article 333. If the widowed mother who has contracted a subsequent marriage should again become a widow, she shall recover from this moment her parental authority over all her unemancipated children. 172. Chapter 5. Adoption. Article 334. Every person of age, who is in full possession of his civil rights, may adopt. 173a. Article 335. The following cannot adopt. 1. Those who have legitimated, acknowledged natural children, or natural children by legal fiction. 2. The guardian, with respect to the ward, before the final approval of his accounts. 3. A married person, without the consent of the other spouse. 4. Non-resident aliens. 5. Resident aliens with whose government the Republic of the Philippines has broken diplomatic relations. 6. Any person who has been convicted of a crime involving moral turpitude, when the penalty imposed was 6 months' imprisonment or more. 174a. Article 336. The husband and wife may jointly adopt. Parental authority shall, in such case, be exercised as if the child were their own by nature. N. Article 337. Any person, even if of age, may be adopted, provided the adopter is 16 years older. 173a. Article 338. The following may be adopted. 1. The natural child by the natural father or mother. 2. Other illegitimate children by the father or mother. 3. A stepchild by the stepfather or stepmother. N. Article 339. The following cannot be adopted. 1. A married person, without the written consent of the other spouse. 2. An alien with whose government the Republic of the Philippines has broken diplomatic relations. 3. A person who has already been adopted. N. Article 340. The written consent of the following to the adoption shall be necessary. 1. The person to be adopted, if 14 years of age or over. 2. The parent's guardian or person in charge of the person to be adopted. N. Article 341. The adoption shall 1. Give to the adopted person the same rights and duties as if he were a legitimate child of the adopter. 2. Dissolve the authority vested in the parents by nature. 3. Make the adopted person a legal heir of the adopter. 4. Entitle the adopted person to use the adopter's surname. N. Article 342. The adopter shall not be a legal heir of the adopted person, whose parents by nature shall inherit from him. 177a. Article 343. If the adopter is survived by legitimate parents or ascendants and by an adopted person, the latter shall not have more successional rights than an acknowledged natural child. N. Article 344. The adopter may donate property, by an act inter vivos or by will, to the adopted person, who shall acquire ownership thereof. N. Article 345. The proceedings for adoption shall be governed by the rules of court insofar as they are not in conflict with this code. N. Article 346. The adoption shall be recorded in the local civil register. 179a. Article 347. A minor or other incapacitated person may, through a guardian ad litem, ask for the rescission of the adoption on the same grounds that caused the loss of parental authority. N. Article 348. The adopter may petition the court for revocation of the adoption in any of these cases. 1. If the adopted person has attempted against the life of the adopter. 2. When the adopted minor has abandoned the home of the adopter for more than 3 years. 3. When by other acts the adopted person has definitely repudiated the adoption. N. Chapter 6. Substitute parental authority. N. Article 349. The following persons shall exercise substitute parental authority. 1. Guardians. 2. Teachers and professors. 3. Heads of children's homes, orphanages, and similar institutions. 4. Directors of trade establishments, with regard to apprentices. 5. Grandparents. 6. The oldest brother or sister. Article 350. The persons named in the preceding article shall exercise reasonable supervision over the conduct of the child. Article 351. A general guardian or a guardian over the person shall have the same authority over the ward's person as the parents. With regard to the child's property, the rules of court on guardianship shall govern. Article 352. The relations between teacher and pupil, professor and student, are fixed by government regulations and those of each school or institution. In no case shall corporal punishment be countenanced. The teacher or professor shall cultivate the best potentialities of the heart and mind of the pupil or student. Article 353. Apprentices shall be treated humanely. No corporal punishment against the apprentice shall be permitted. Article 354. Grandparents and in their default the oldest brother or sister shall exercise parental authority in case of death or absence of the child's parents. If the parents are living, or if the child is under guardianship, the grandparents may give advice and counsel to the child, to the parents or to the guardian. Article 355. Substitute parental authority shall be exercised by the grandparents in the following order. 1. Paternal grandparents. 2. Maternal grandparents. Title 12. Care and Education of Children. Article 356. Every child 1. Is entitled to parental care. 2. Shall receive at least elementary education. 3. Shall be given moral and civic training by the parents or guardian. 4. Has a right to live in an atmosphere conducive to his physical, moral and intellectual development. Article 357. Every child shall 1. Obey and honor his parents or guardian. 2. Respect his grandparents, old relatives, and persons holding substitute parental authority. 3. Exert his utmost for his education and training. 4. Cooperate with the family in all matters that make for the good of the same. Article 358. Every parent and every person holding substitute parental authority shall see to it that the rights of the child are respected and his duties complied with, and shall particularly, by precept and example, imbue the child with high-mindedness, love of country, veneration for the national heroes, fidelity to democracy as a way of life, and attachment to the ideal of permanent world peace. Article 359. The government promotes the full growth of the faculties of every child. For this purpose, the government will establish, whenever possible, 1. Schools in every barrio, municipality and city where optional religious instruction shall be taught as part of the curriculum at the option of the parent or guardian. 2. Puericulture and similar centers. 3. Councils for the protection of children, and 4. Juvenile courts. Article 360. The Council for the Protection of Children shall look after the welfare of children in the municipality. It shall, among other functions, 1. Foster the education of every child in the municipality. 2. Encourage the cultivation of the duties of parents. 3. Protect and assist abandoned or mistreated children and orphans. 4. Take steps to prevent juvenile delinquency. 5. Adopt measures for the health of children. 6. Promote the opening and maintenance of playgrounds. 7. Coordinate the activities of organizations devoted to the welfare of children, and secure their cooperation. Article 361. Juvenile courts will be established, as far as practicable, in every chartered city or large municipality. Article 362. Whenever a child is found delinquent by any court, the father, mother, or guardian may in a proper case be judicially admonished. Article 363. In all questions on the care, custody, education and property of children, the latter's welfare shall be paramount. No mother shall be separated from her child under 7 years of age, unless the court finds compelling reasons for such measure. Title 13. Use of surnames, n. Article 364. Legitimate and legitimated children shall principally use the surname of the father. Article 365. An adopted child shall bear the surname of the adopter. Article 366. A natural child acknowledged by both parents shall principally use the surname of the father. If recognized by only one of the parents, a natural child shall employ the surname of the recognizing parent. Article 367. Natural children by legal fiction shall principally employ the surname of the father. Article 368. Illegitimate children referred to in Article 287 shall bear the surname of the mother. Article 369. Children conceived before the decree annulling avoidable marriage shall principally use the surname of the father. Article 370. A married woman may use 1. Her maiden first name and surname and add her husband's surname, or 2. Her maiden first name and her husband's surname, or 3. Her husband's full name, but prefixing a word indicating that she is his wife, such as Mrs. Article 371. In case of annulment of marriage, and the wife is the guilty party, she shall resume her maiden name and surname. If she is the innocent spouse, she may resume her maiden name and surname. However, she may choose to continue employing her former husband's surname, unless 1. The court decrees otherwise, or 2. She or the former husband is married again to another person. Article 372. When legal separation has been granted, the wife shall continue using her name and surname employed before the legal separation. Article 373. A widow may use the deceased husband's surname as though he were still living, in accordance with Article 370. Article 374. In case of identity of names and surnames, the younger person shall be obliged to use such additional name or surname as will avoid confusion. Article 375. In case of identity of names and surnames between ascendants and descendants, the word junior can be used only by a son. Grandsons and other direct male descendants shall either 1. Add a middle name or the mother's surname, or 2. Add the Roman numerals 2, 3, and so on. Article 376. No person can change his name or surname without judicial authority. Article 377. Usurpation of a name and surname may be the subject of an action for damages and other relief. Article 378. The unauthorized or unlawful use of another person's surname gives a right of action to the latter. Article 379. The employment of pen names or stage names is permitted, provided it is done in good faith and there is no injury to third persons. Pen names and stage names cannot be usurped. Article 380. Except as provided in the preceding article, no person shall use different names and surnames. Title 14. Absence. Chapter 1. Provisional measures in case of absence. Article 381. When a person disappears from his domicile, his whereabouts being unknown, and without leaving an agent to administer his property, the judge, at the instance of an interested party, a relative, or a friend, may appoint a person to represent him in all that may be necessary. This same rule shall be observed when under similar circumstances the power conferred by the absentee has expired. 181a. Article 382. The appointment referred to in the preceding article having been made, the judge shall take the necessary measures to safeguard the rights and interests of the absentee and shall specify the powers, obligations and remuneration of his representative, regulating them, according to the circumstances, by the rules concerning guardians. 182. Article 383. In the appointment of a representative, the spouse present shall be preferred when there is no legal separation. If the absentee left no spouse, or if the spouse present is a minor, any competent person may be appointed by the court. 183a. Chapter 2. Declaration of absence. Article 384. 2 years having elapsed without any news about the absentee or since the receipt of the last news, and 5 years in case the absentee has left a person in charge of the administration of his property, his absence may be declared. 184. Article 385. The following may ask for the declaration of absence. 1. The spouse present. 2. The heirs instituted in a will, who may present an authentic copy of the same. 3. the relatives who may succeed by the law of intestacy. 4. Those who may have over the property of the absentee some rights subordinated to the condition of his death. 185. Article 386. The judicial declaration of absence shall not take effect until 6 months after its publication in a newspaper of general circulation. 186a. Chapter 3. Administration of the property of the absentee. Article 387. An administrator of the absentee's property shall be appointed in accordance with Article 383, 187a. Article 388. The wife who is appointed as an administratrix of the husband's property cannot alienate or encumber the husband's property, or that of the conjugal partnership, without judicial authority. 188a. Article 389. The administration shall cease in any of the following cases. 1. When the absentee appears personally or by means of an agent. 2. When the death of the absentee is proved and his testate or intestate heirs appear. 3. When a third person appears, showing by a proper document that he has acquired the absentee's property by purchase or other title. In these cases the administrator shall cease in the performance of his office, and the property shall be at the disposal of those who may have a right thereto. 190. Chapter 4. Presumption of death. Article 390. After an absence of 7 years, it being unknown whether or not the absentee still lives, he shall be presumed dead for all purposes, except for those of succession. The absentee shall not be presumed dead for the purpose of opening his succession till after an absence of 10 years, if he disappeared after the age of 75 years. An absence of 5 years shall be sufficient in order that his succession may be opened. N. Article 391. The following shall be presumed dead for all purposes, including the division of the estate among the heirs. 1. A person on board a vessel lost during a sea voyage, or an aeroplane which is missing, who has not been heard of for 4 years since the loss of the vessel or aeroplane. 2. A person in the armed forces who has taken part in war, and has been missing for 4 years. 3. A person who has been in danger of death under other circumstances and his existence has not been known for 4 years. N. Article 392. If the absentee appears, or without appearing his existence is proved, he shall recover his property in the condition in which it may be found, and the price of any property that may have been alienated or the property acquired therewith, but he cannot claim either fruits or rents. 194. Chapter 5. Effect of absence upon the contingent rights of the absentee. Article 393. Whoever claims a right pertaining to a person whose existence is not recognized must prove that he was living at the time his existence was necessary in order to acquire said right. 195. Article 394. Without prejudice to the provision of the preceding article, upon the opening of a succession to which an absentee is called, his share shall accrue to his co-heirs, unless he has heirs, assigns, or a representative. They shall all, as the case may be, make an inventory of the property. 196a. Article 395. The provisions of the preceding article are understood to be without prejudice to the action of petition for inheritance or other rights which are vested in the absentee, his representatives or successors in interest. These rights shall not be extinguished, save by lapse of time fixed for prescription, in the record that is made in the registry of the real estate which accrues to the co-heirs. The circumstance of its being subject to the provisions of this article shall be stated. 197. Article 396. Those who may have entered upon the inheritance shall appropriate the fruits received in good faith so long as the absentee does not appear, or while his representatives or successors in interest do not bring the proper actions. 198. Title 15. Emancipation and Age of Majority. Chapter 1. Emancipation. Article 397. Emancipation takes place 1. By the marriage of the minor. 2. By the attainment of majority. 3. By the concession of the father or of the mother who exercise parental authority. 314. Article 398. Emancipation treated of in No. 3 of the preceding article shall be effected in a public instrument which shall be recorded in the civil register, and unless so recorded, it shall take no effect against third persons. 316a. Article 399. Emancipation by marriage or by voluntary concession shall terminate parental authority over the child's person. It shall enable the minor to administer his property as though he were of age, but he cannot borrow money or alienate or encumber real property without the consent of his father or mother, or guardian. He can sue and be sued in court only with the assistance of his father, mother, or guardian. 317a. Article 400. In order that emancipation by concession of the father or of the mother may take place, it is required that the minor be 18 years of age, and that he give his consent thereto. 318.